Good morning, welcome. I'm seeing people come on. Good morning. We're going to give it just a minute to see, to give everybody a chance to log on, but good morning. We're so glad that you're with us this morning. We'll start in just a minute. Hello, everybody. Hello. There's a lot of people logging on, so this is fantastic. It's good to see everybody this morning. Does anybody know any good lawyer jokes that we can tell the attendees before we start? No? Okay. Well, we've got a good number of people already logged on. We'll welcome everybody as people log on as we continue, but let's go ahead and get started. Good morning. My name is Molly Blazek. I'm an attorney here in Omaha, and this morning I have the privilege of hosting an awesome attorney panel where we have fields of law represented beyond guardianship and conservatorship. And so today is going to be an amazing opportunity to ask questions that you wouldn't normally get to ask us during our normal attorney panels. We've got family law, estate planning, we've got guardian ad litems, we've got legal aid of Nebraska, and we even have a special guest from the Douglas County Sheriff's Office to talk about the intersection of law enforcement and other areas of law. So this is going to be very conversational. If you have questions, I'm going to be monitoring them in the Q&A. So please ask them in the Q&A. We'll try to get every question answered over the next hour. We're so glad that you're here with us. And I am going to introduce our wonderful panel. Let's start with Dina Klein. Dina, can you tell these folks who you are and what area of law you're covering this morning?
Yeah, so I'm Dina Klein. I am an attorney at the Dornan Law Team. I practice in a variety of areas. But one of my favorites is serving as a guardian ad litem in guardianship cases, and that is the area that I'm covering today.
Thank you, Dina. We're so glad that you're here. Okay, let's go to Tasha Havikin. Tasha, welcome.
Good morning to the panelists and to all the attendees. My name is Tasha Havikin. I am a partner with Hightower Ref Law, and I do mostly transactional law cases. And the area that I'm focusing on this morning is estate planning. So things like wills and trusts and how we plan for those things in light of adult disabled persons. So good morning.
Welcome. We also have another attorney from Hightower Ref, Sarah Hart. Good morning. Welcome. Why don't you tell these attendees a little bit about yourself?
Good morning. Yes, I am an attorney at Hightower Ref, and I mainly focus on family law, so divorce, custody. I do some guardianships as well. So today I am covering the family law section.
Welcome. Thank you so much for being here. Okay, let's go to Elena. Elena is an attorney with Blazek Law Group. Elena, why don't you introduce yourself to the attendees this morning?
Good morning. My name is Elena. I'm an associate attorney. I work with Molly here at Blazek Law Group. I've been in private practice about 2.5 years, and I do a lot of guardianships with Molly, some real estate work as well, and I have a bit of estate planning experience too.
Thank you for being here. And Jane Wagner is here from Legal Aid of Nebraska. We're so excited that she's here. Jane, would you introduce yourself?
Sure. So I'm Jane Wagner. I have been with Legal Aid Nebraska for about 8 years now. And some of the things Legal Aid of Nebraska does is we a lot of disability work, public benefits, housing, family law, and then also I have an area where we cover guardianships and a lot of probate cases as well.
Thank you so much. And last but certainly not least, our special guest, Deputy David Christensen from the Douglas County Sheriff's Department. Good morning, welcome. Thank you for being here. Would you tell these attendees a little bit about yourself?
Good morning. I appreciate you having me today. So my name is Deputy David Christensen, and I'm with Douglas County Sheriff. Been a deputy for over 24 years, and I'm here to answer any law enforcement related questions that you have.
Thank you so much for being here. Okay, well, nobody has been brave enough to ask a question yet in the Q&A, so I do have some questions that were submitted ahead of time, and I'm going to start off with those. One of them is particularly interesting to me because I don't necessarily have a lot of experience in family law, but something that comes up in my guardianship cases is dealing with guardianship when you have an adult disabled child who's now reached the age of majority and a guardianship is needed, but the parents are divorced. And sort of the landscape that I've seen happen in the cases where I've been involved has been that whatever the custody arrangement was in the divorce case sort of transitions into what the guardianship situation will be, meaning the custodial parent will typically become the guardian, and then the non-custodial parent will maybe be appointed a standby guardian or perhaps not at all. And so I'd like to submit the question to our panel. How does, I guess first let's talk about divorce. So before a special needs child reaches age 19, what considerations, if any, are there in a divorce situation when you have a minor child who has maybe intellectual disability or developmental disability? Does our panel have any thoughts about that?
I think when you're looking at children with any kind of disability, if they're getting Social Security benefits, that has to be taken into account when you are going through a divorce. Those can't be split. It's not something that is just going to go equally to each parent. So that's something you need to take into account, that someone is going to have to be the primary parent. And then if you know that this child is going to go into adulthood with these disabilities and a guardianship might be present, it's better to go ahead and work through those details and see what kind of needs this child is going to have. You might want to look at extra support after the age of 19, any kind of medical support, what kind of medical insurance they have, life insurance. All of those things need to be taken into account when you're planning for the future of the child.
Is it pretty typical to expect that the custodial arrangement will result in the guardianship action? So the custodial parent will become the guardian?
Not always. And I think Dina Klein has some experience with this. So I'm
sure.
Sure. Let her talk.
So I think I don't think you necessarily go with the default, and I think parents can get into trouble if they think that that just may be the case. As we all know, like all people, but especially kids, and as they're growing into adulthood, their needs change, their circumstances change, potentially their relationships with the custodial parent may change. The households change post-divorce, and so sometimes what was a household that was able to best meet a child's needs maybe no longer is the household that can best meet the child's needs. And so the guardianship is an opportunity to take a second look if one needs to be taken. But you want to, in my opinion, avoid relitigating custody in the context of a guardianship. So it is, in my opinion, best to kind of think through as far as possible when doing a parenting plan in a divorce and when making decisions about custodial arrangements. There's legal custody and physical custody. And physical custody is the easiest way to explain is where a child lays their head at night. What is the schedule? That can be joint, that can be sole, that can be any iteration of overnights that best meets that child's needs and fits the family well. But legal custody is the decision-making authority for a particular child. So the place where we run into issues with a guardianship where there's been a prior custodial arrangement and the default of maybe joint legal and joint physical just can't exist anymore, as this happens in Douglas County when now we can only have one guardian. We cannot have co-guardians. So even if the parents enjoyed joint legal custody in the context of a parenting plan and a divorce decree, after that child is 19, the parents cannot serve as co-guardians in Douglas County. So some things to consider would be in a parenting plan or a decree kind of mentioning future intentions of what we think it should be. Potentially there's an opportunity to file for a guardianship in a county where co-guardianship is allowed. That would be ideal, especially if joint legal custody has been going well. We should consider ongoing types of disability payments or Social Security payments. Who is that going to go to? And if custody is split, is that going to be split? And I was taking some notes earlier, something that just kind of popped into mind is in Nebraska, even though the requirement generally ends to provide financial support for a minor child at the age of 19 to include health insurance. We know that persons require health insurance beyond that time. And if it's a developmentally disabled child that we don't believe is going to be able to obtain their own health insurance, or Medicaid is generally an option as well, but potentially a parent still has access and is able to carry that child under their policy, we want to consider that and plan for that. And how are the parents going to divide and split the uncovered costs if there is not a secondary provider like Medicaid? So there's a lot of different iterations to work through and to just think about. It shouldn't be, oh, well, it's easy to settle custody. Let's just say it's joint, and then we'll deal with this again when the child ages out in a guardianship context. The probate court is not as well equipped, in my opinion, to deal with all of those issues as the court presiding over a dissolution or custody action is able to.
That's really great information. I think along those lines, something else that we could maybe talk about, which was kind of a question that was asked ahead of time, is how families maybe in this situation can deal with visitation in guardianships. And that's something that we've seen within our own cases, because now there's a specific section of the probate code that allows for court-ordered visitation within guardianships. Does anybody want to maybe talk about that, like how parents could address that if they're a divorced family in a guardianship, and particularly in Douglas County, where only one of them can serve?
I had something like that recently, and I think to build off of what was previously said by Dina and Sarah is that taking into account which parent is better equipped to be able to handle a child. This is a full-time job, essentially, is taking care of an adult disabled child, and which parent has like the better access as far as like in the home. Do you need to have wheelchair access? Do you need to have wheelchair access in the future? And I think that as far as saying that visitation, I think it just kind of depends on the households, especially in our cases where, that families may not have as much, or that there may be one parent that has a better home than the other, just better equipped. I think those are things that need to be taken into consideration, and that maybe visitation has to just be in one home just because of those limitations that the child may have.
Do you think that it's important to address visitation within the context of a divorced family when a guardianship is being established?
I think that it would be important because, again, this child is going to need both parents. That would be ideal for the rest of their life, and that it's important for both parents to stay involved in case, like in Douglas County, if we have one person that's serving as guardian, then it'll make an easier transition if the other parent falls ill, or if the other parent gets in a car accident, things like that. Then the other parent is better equipped to be able to step in, would be a smoother transition. And that I think it's important to have, both parents still involved, even though one may be the guardian at the time, just to be able to make sure that the child will outlive both parents, likely, as a disabled child. And so you need to be prepared for that.
I think too, what's and this is, I don't do much in terms of family law, but within the guardianship court context, the new visitation statutes, and you can correct me if I'm wrong, Molly, but I think they only apply within the context of adult disabled persons, at least the way that I've seen the forms that have been set out by the Supreme Court. And so prior to that child turning 19, we're looking at a best interest standard. And the interesting thing, at least from my perspective, when you're going through the dissolution court and district court, you do have the benefit, if you utilize it to your benefit, mediated services in order to mediate a parenting plan, whereas the county courts in the probate sector are not requiring mediation. They're not set up to necessarily, I mean, it doesn't mean you can't mediate, but it's not something that is court ordered or any parties are obligated to participate in. Whereas if you're going through a divorce, you can go through the mediative process and do a mediated parenting plan. And if you come into that mediation saying, okay, we need to do a mediation for parenting plan for our child, and also telling the mediator, you need to understand that this mediated parenting plan is going to have potentially long-term effects, because if we can establish good, kind of boundaries and guidelines and rules for this visitation, we could potentially transfer that and utilize that in the guardianship court so that everything just transitions more smoothly. Everybody's on the same page, and we can kind of, there's consistency and continuity for the adult disabled person who is really, that's who we're trying to protect and, give the best chance at both parents being involved. So I think if you can really utilize that mediation services within the district court, you could really set yourself up for a lot of success.
And just to touch on that, Tasha, I completely agree that within the context of the probate code, the visitation section really was sort of born at the same time that the law changed with respect to isolation. Isolation has become a really problematic thing in guardianships where one person has the unilateral authority to allow access and visits and things like that to a vulnerable person. And so, yes, the law really only addresses adult guardianships, but I think it's important for all the guardians watching to know that that is something that is within their ability, with or without a court order. The Supreme Court has said very clearly in case law that you have the authority to allow visits or to restrict visits when that might be necessary for the person that you serve for. So the benefit of having the court-ordered visitation, I've found, is within those cases where either there is some contention and we need a guideline that's enforceable, or maybe we've got a situation where in the past a family member has, unfortunately, the attorneys on this panel, like myself and Ms. Wagner and Ms. Klein, oftentimes we're involved in guardianships where family members may have abused or misappropriated money from the vulnerable adult that they were previously serving for. And in those situations, when we come in, we don't necessarily want to say you can't see your family anymore because a bad decision was made, but we need to have some guidelines and some rules about how that's going to look. Maybe it needs to be in a neutral location. Maybe it needs to be on a certain day. Maybe there needs to be a certain kind of supervisor. And so the court-ordered visitation, I think, is really only necessary when there's a reason for judicial oversight. Otherwise, this is well within a guardian's ability to just approve and allow to happen whenever they want in the best interest of their ward. We do have a couple of questions in the Q&A. So there's one that I need a little bit more information on. So the first question is, do I have to appear before the judge to pay monthly care for my handicapped son? After a recent surgery, he can't attend day services, and I'm looking at paying $1,600 a month for rehab for the next 8 months. And so I'd like to know a little bit more about that question, because the answer is going to depend on whose money you're talking about and whether or not you have a budget in your guardianship case. So we'd love to be able to answer that question, but just need a little bit more context. Unless somebody else has a different idea of what the question is asking. I think the question is asking, am I allowed to spend money without court approval? And so we just need to know a little bit more about the case in order to answer that question. So please clarify that in the Q&A, and we will definitely get to that question. We have another question in the Q&A. My wife and I have served as co-guardians for our 38-year-old son here in Douglas County. The arrangement has worked well, but are you recommending that we dissolve this now? The answer, I think unequivocally, is no. That's not what was being mentioned earlier. Dina, I think you were the one who talked about that local rule. Can you explain a little bit more?
Absolutely. So there's a new local, I guess it's not new anymore, but there's a local rule that now exists in Douglas County, I would say, I guess within the last 5 years. It came into play where no longer in new guardianships are co-guardians allowed to be appointed. If a co-guardianship already exists and is working well, by all means, it should continue. to persist and go on, because at the end of the day, we're always looking at what's in the best interest of the board. So if it's working well, it should continue to go forward. Other counties, it's a local rule, so that's a specific rule to Douglas County. Other counties still allow for co-guardians, and that's where I mentioned, if joint legal custody is going well and has been going well, and the parents are able to make good decisions in the best interests of their child together, and it's an option to file in a county that allows co-guardians, in my opinion, that would be preferential, because it's always best to have parents who can work together to provide for their child, whether that child is a minor or whether that child is an adult.
Yes. We have another question in the Q&A, and I think that this is a good segue into maybe a different topic than guardianships. This person is asking us to address power of attorney for elderly parents. So Tasha, are you able to talk about power of attorney in that type of situation? I always joke with everybody that they should never want to have to hire me, because guardianship should be a last resort. So if you have a power of attorney, you may not ever have to be in my office, and that's okay, because Tasha's going to tell you how to do that right now.
Yes, so typically when I counsel clients about estate planning, the goal is to try to avoid the court system if at all possible, because it's typically more expensive, it takes more time, and it's public. I mean, for the most part, you can go down to the courthouse and look up any guardianship case that you want, and it's all public record. So when we're talking about powers of attorney, there are two kinds that I typically counsel clients on. The first one is going to be a power of attorney for healthcare decisions. So that document is springing. And so what that means is that you always maintain the right to make your own healthcare decisions so long as you are competent. And once a doctor has determined that you no longer are competent, then that document kind of springs into action, and it allows the agent, the person that you have nominated, to make healthcare decisions in your stead. And there's kind of two scenarios that we try to plan for under that document. One is going to be more the day-to-day decisions, things like, you know, what treatments are you receiving? What doctors are you seeing? Where are you receiving that treatment? Where are you residing? This person's going to have access to your medical records, all that kind of stuff. And then the second scenario that I try to work through with clients is those end of life care decisions, when we're talking about terminal conditions, persistent vegetative state, those types of things, and what the person who's signing the document would want to have happen. So that gives authority over those types of decisions. The other type of document is a power of attorney for finances. There's two kinds. Power of attorney for finances, that's just a general durable power of attorney. So as soon as you sign it, you're giving somebody else authority to make decisions about your finances, take money out of your accounts, move your stocks around, all those kinds of things. You can also, instead, you can do what's called a springing durable power of attorney, which is similar to the healthcare one, where you sign it now, but it's only effective once the person who signed it is deemed incompetent. And if you have enforceable powers of attorney, then you typically do not have to get a guardianship in court for an adult disabled person. Hopefully that answers the question. I don't know. I mean, most of the time, so in a situation where you're wanting a parent to, you know, the parent would be the client, and that would be the person that would contact me and say, hey, Tasha, you know, we're getting up in age and we want to make sure that we're prepared for if something were to happen. And so then they get to choose who they want to serve. And I typically will do one or two successors. So for example, if you choose a spouse and that spouse for whatever reason can't serve, then it would go to the next person. And so then a part of the conversation too is talking about what person in your life is the most appropriate choice, right? We don't want to pick the child that always causes the fights at Thanksgiving, right? We want to try to think about who's going to make the most sense to be helping you in making those decisions, and who do you trust. Do you ever reach a point where you will consult
with the person to maybe get a medical opinion about their ability to nominate a person. Can you talk maybe a little bit about the capacity that's required to, I guess, nominate a surrogate decision maker in a POA document?
Yes, so I work with clients kind of at varying stages in life. Some people are very healthy and no issues, and I think it's, you know, pretty clear that they don't have any competency issues. I actually had a signing on Tuesday with a gentleman who is terminal, and he's on some pretty heavy medications, and in the afternoons he really is not with it, you know, because by that point in time his medication is really kicked in, and so we had to postpone the signing because it was very clear to me that he didn't really even know who I was, or, you know, those types of things. I've also counseled clients, especially in situations where we are anticipating that maybe other family members will try to fight the nomination or something like that. I will have them go to their doctor and talk with their physician and do almost kind of like a mini mental exam so that the doctor can put in their medical file, you know, listen, this person came in and I evaluated them and I believe that they are competent, that they understand what's going on, they understand what assets they have, and they understand who they want to benefit and who they want to receive those assets. And that just helps bolster the enforceability of those documents. Because I mean, anybody can sue anybody for $44 in county court, right? So trying to kind of lessen the ability of folks like that to contest those documents. If we have any concern at all, there's things that we can do to try to make sure that those documents are enforceable. And I have had clients do that.
Okay, well, if there are any more questions about powers of attorney, put them in the Q&A. We will tackle them. We've got 30 minutes left, so we have a lot of time to get to your questions. Deputy Christensen, I want to ask you a law enforcement question that comes up in guardianship cases, and that is something that people don't often know. When you file for a guardianship, you are required to personally serve the person that you're saying needs a guardian. And when I tell this to people, especially parents and children who are seeking a guardianship over a family member, I mean, the look on their face is like sheer terror that the sheriff is going to have to come and deliver these papers to the vulnerable adult. And so one of the things that we talk about with our clients is, you know, this process is not adversarial. You know, there's a plainclothes deputy in just a regular car. And so I'm just curious from your perspective, like what sort of training and what sort of things happen when law enforcement is in a situation like that, having to serve papers on a vulnerable adult? Can you comment on that?
Yeah, so when papers are served like that, it's not, we don't show up in uniform. We're not showing up in a marked cruiser. They're plain, like I said, they're plain clothes. Yeah, they go through training. They try to not make it a stressful event for people. They're respectful. They use, you know, a tone of voice that's not overwhelming for anyone. They're sincere, they're respectful, and they're honest. They, you know, say why they're there, and they make the process as easy as they can. So it's not intimidating and people feel comfortable.
If somebody has special needs in that kind of situation, are deputies accommodating? Like, for example, sometimes we'll have someone who's nonverbal, you know, and maybe confined to a wheelchair that has to be personally served. Or Jane, you know, I think you probably have situations where maybe somebody's in the hospital, you know, and they're in a hospital room and can't leave. You know, are there things that can be done in order to make arrangements for service? Like, are we allowed to contact the deputies and say, you know, this person needs their caregiver present, they're not at home, they're at the hospital, or they're nonverbal and they need somebody else present to facilitate the service of papers? Is that something that is available through the Douglas County Sheriff's Department?
Absolutely, and we really welcome that, because the more information we have, the better and then smoother it's going to go. So yeah, we welcome it. they're more than welcome to contact us and pass it on to the deputies or the process servers, and that just helps us out. And yeah, again, we just welcome it.
Okay, well, that's very good to know. And there's a special part of the sheriff's department that deals with civil process only, right?
Correct.
Okay. All right, so I've got a little bit of information about that question I mentioned earlier. So the question about using money to pay for rehab is going to be from an Enable Savings Plan. So I would like to use funds from the Enable Savings Plan to pay for personal support services that are being provided by a caregiver. United Healthcare denied the rehab hospital stay, but did approve outpatient rehab. And so this person is asking if she can use Enable funds to pay for medical expenses, essentially. And this actually ties into a question that we had from before we started the panel, which is whether Enable accounts are worth it. Does anybody have a lot of experience with Enable accounts and could answer that? And I know I can talk about it if nobody else does. Okay, it's me. Okay, Elena, no, you don't want to? Okay, all right. So I subscribe to Enable accounts being a wonderful thing. There are a lot of different opinions about Enable accounts, but I think it is a wonderful thing for guardianship and conservatorship cases or people who otherwise have disabilities that are on needs-based government benefits. So that would be like SSI and Medicaid. Those are examples of need-based government benefits. Before the Enable Savings Plan became available, you had certain resource limits and income limits that prohibited you from going over, otherwise you'd be disqualified for your benefits. But Enable Savings Plans permit people who are receiving needs-based government benefits to save money up to $100,000. Now, there are some different rules involved, and we don't need to get into all of those details here, but one of the ways that you can use an Enable Savings Plan is for medical expenses because they are qualified disability expenses. Now, the most important takeaway is that you can't use an Enable Savings Plan for any kind of expenses. It's not unfettered access. They have to be qualified disability expenses. And there are some examples of that. And we've done workshops in the past that cover that. So if you want to check those out, you can absolutely do that at guardianconnectnow.com. But the short answer for using the Enable Savings Plan on these types of medical expenses, this is truly a perfect example of what an Enable Savings Plan is for. So if you have uncovered medical expenses and you have funds in an Enable account, absolutely use them. And unless you are under a court-ordered budget, you will be able to use them without asking anybody permission to do so. If you have a court-ordered budget where you are required to follow certain spending limits, then you're going to want to get permission from the court to do that. You might even consider terminating your budget. I'm becoming less of a fan of budgets. The rules have the forms have changed for how you use budgets, so I'm less of a fan of them. But that would be the one qualification, that you can't just take money out of a Enable Savings Plan without court permission if you're under a court approved budget. But I can't imagine a judge denying that if you explained the purpose of the disability expense. So this is a wonderful example of how Enable Savings Plans are very useful. And I very much support them in my own guardianship and conservatorship cases where I'm serving as guardian. I think Enable Savings Plans are great. So we've got more Q&A, so let's keep at it. We are usually notified at the beginning of the month to file our guardian report due the next month. Has Douglas County changed their procedure? Does anybody want to talk about notices that get sent out from the court for annual report reminders?
Well, I believe they send out, oh, go ahead, Jane. Go ahead, Jane.
Okay, I was just gonna say, I think that they do normally send out, I think it's important that you keep an updated address with the court so that they're sending it to the right address, but also I think that we know as attorneys kind of the turnover that's happened in the Douglas County court clerk's office, and I think that you just have to be patient with them because a lot of them are new and that things may fall beneath the cracks. So I think that Normally what I advise people is just kind of mark it on your calendar every year that it's a year from your letters. It should say on your guardianship letters when your report is due, and just kind of keep track of that, because you should get a notice from the court, but that doesn't always happen.
One of the things that I know the clerk's office is really trying to crack down on is, in the past, when you filed your annual report late, your due date the following year changed. And so that provides, well, I guess it created a lot of confusion for when people's annual reports are due. But one of the things that Douglas County is specifically doing is trying to make everybody's due date consistent, whether or not you file your report late. And so the way you can always tell what your due date is that if your guardianship was established before April of 2020, then your annual report is due 13 months after the date of your letters. So that gives you 12 months of accounting and 1 month to do the report. And that due date from the date of your letters will be the same every single year. That changed a little bit in April of 2020 when there was kind of an overhaul on some rules and some forms. And now that is 13 months from the date that the order was signed appointing you. So if you're pre-April 2020, it's 13 months from the date of letters, and then it's going to be the same every single year. If you're a guardian who's been appointed after April 2020, then it's 13 months from the order appointing you. I think that might be something worth noting, because I talk to a lot of people who don't really recognize that guardianship actually happens in two steps. You first get permission from the court, which is the order appointing you, but then you actually get your authority when the letters of guardianship are issued. So those are two very different dates within guardianship cases, and sometimes they are not close together. So it's very important to know which date you're under and when your annual report is due. And you are allowed to file an annual report even if you haven't received notice from the court. So that's something that is up to the individual guardian and conservator. You're required to submit the report even if you haven't been reminded. It's sort of like invoicing for a credit card statement. If you ever read the fine print of your credit card agreement, it says, we don't have to invoice you. You still owe us the money at the first of the month. It's kind of the same concept in guardianships and conservatorships. You owe the report to the court whether you've been reminded or not. So it's very important to know around the time that your report is due. But courts are very understanding if you're a few days late, and it's not a huge deal as long as you're somebody who's transparent with the court. So that's just an extra note on annual reports. One thing that I want to talk a little bit about before we get done, just because I want to make sure that it's covered, is Board of Mental Health commitments. This is something that I don't know that everybody deals with in their practice, but I often do, especially when we have guardianships that are based in mental health. I always tell people that there are three kind of main areas of guardianship, and I'll see if my colleagues agree with me. I think that guardianship shows up when you've got developmental disabilities, ID, DD, things like that. Then you've got age-related cognitive guardianships. So elderly people, or maybe not even elderly people if there's early onset, but cognitive reasons for a guardianship, Parkinson's, Alzheimer's, dementia, that sort of thing. But then there's this middle kind of the road guardianship, which is mental health. And mental health guardianships are by far the most difficult guardianships for the ward and for the guardian, simply because there are just not a lot of resources for people who have mental health diagnoses. And one of the things that makes mental health guardianships really challenging is that oftentimes, if somebody is regulated and taking their medication pursuant to their diagnosis, they really don't need surrogate decision-making. And so you kind of ride this line of, somebody can be independent and make their own decisions until maybe they stop taking their medication, and then they need to be, sometimes they have to go to the hospital to help them re-regulate and take their meds, and maybe get a new placement, and maybe adjust the medications, or get a new diagnosis, or whatever the case might be. And especially from the guardianship perspective, it's very difficult when you're dealing with somebody who's in crisis, having a mental health episode, because guardianship does require some cooperation from the vulnerable adult. We can't drag people kicking and screaming to the hospital or to the emergency room or to the jail or to wherever. So it gets very hard when you have somebody who's uncooperative and who's also, you're charged with making their decisions. And so one of the things that we've done is when it's necessary, we'll file a Board of Mental Health commitment on behalf of somebody that we're serving for. And there are different standards that have to be met in order for somebody to qualify for a commitment. But one of the areas of practice that I don't think attorneys know very well is what actually happens when you file a commitment over somebody. And I think because we have Deputy Christensen on the panel, he can certainly help explain what that happens. So let's say the board signs a commitment and then an order says you go pick up this person and take them to Emmanuel. What happens from there?
Well, every order that we would get, it's a priority. There's a special unit that serves those BMHs, and they have other duties that they do. But when a Board of Mental Health warrant comes across the desk, it's priority, and we drop everything that we're doing and we attempt to serve them. And usually we get enough information. We'll have contact people that we can call and talk to, and where they're at. But we take it very serious. We don't push it off to the side. And if we don't find them, if that unit, I used to work in that unit, and if we don't find them at the end of the day, the order is sent to the West office, and it's sent to Omaha Police as well. And it goes on there. If they're in contact with police, sheriff, state patrol, or anything like that, it's going to come up on the record that the warrant's there, and they'll get instructions to where to take them. And then one of our process servers will actually go to the hospital where they're at and serve them the paperwork.
So when they're located, what type of exchange is that? Is it because you're dealing with somebody who's in crisis and is vulnerable under a guardianship, is it like what you were describing earlier with serving guardianship papers? I mean, what is that like for the vulnerable adult?
I don't know if I understand your question. Once they're served and taken to the hospital?
Well, I guess is it like an arrest, or is it like, hey, you just need to come with us to the hospital? Like, what gets explained to them?
When I was doing it's usually the way I explain to them, like, hey, we're here to help. You're not in trouble. You didn't do anything wrong. We're simply giving you a ride. This is nothing arresting, because it's not technically an arrest. It's a civil commitment. And so talking to them and being calm with them, and, a lot of times we don't put them in handcuffs. If we can talk to them and they're calm, we'll just simply place them in the car and take them to the hospital, or allow them to go to county hospital. So
does the board tell you where to take them? Who makes that decision?
The board will always instruct us where to take them. And a lot of times I've seen, even, I work at the courthouse, and we would still get them. And a lot of times they go to a hospital, to an ER, and they get physically checked out first, and then they're transferred to wherever the board wants them to go.
Okay. All right. Well, it's nice to know that that's not like I guess an adversarial, or, like I guess an arrest type contact. I don't know what the language would be, but it's nice to know that it's not hostile. No,
it's not at all. And we received so much more training on mental illness and Board of Mental Health warrants. So I think we have a lot of knowledgeable deputies out there with that training that can deal with situations like that.
There's another question for you, Deputy Christensen. If someone is a guardian, are they able to report their ward missing, and will the police try to help find them? Are there times that the police will not help in those situations? How does that work?
Well, so every situation is different when it comes to a missing person. We would always take a report, and we'd always enter it into the system. I mean, there's different factors with every case, but if a guardian would say, hey, someone's missing, we're going to take it serious, and we're going to obviously look for them. There's going to be a broadcast. Be on the lookout for this person. So yes, every time, I don't see a situation where we wouldn't take a report and we wouldn't follow up on it.
One of my wards elopes a lot, and so I think reports get filed on this individual quite frequently, and I can say that we've never been told that a report won't be taken. I think local law enforcement is really mindful of the fact that we're dealing with somebody who's a vulnerable adult, and especially a guardian situation, that is, I think, taken very seriously.
Definitely.
As more understanding is now available for people who have mental health diagnoses, maybe not before, but certainly now. So, okay, that's great. I'm very glad for that information. The last question that I had from before the panel started is something for Tasha, and that is, and anybody's welcome to answer, but what kind of estate planning should families with special needs be looking at?
Absolutely, and that's such a great question, because I've had situations where maybe not we, but the families didn't necessarily think about that, and it caused some issues. So earlier in the panel, Molly, you and I think some of the other panelists talked about needs-based benefits. And so when you have an individual who is on these types of programs, a lot of times there are income and asset limitations in order to qualify for these types of benefits. And so if a person is receiving those and then at some point receives an inheritance in their name, then the inheritance, albeit coming from a good place and good intentions, can really affect the person's ability to stay on their benefits. So in order to avoid that, what needs to happen is families can plan for an inheritance to be transferred to a special needs trust. An SNT is going to be overlooked by Social Security Disability. So if the person is receiving SSI benefits, the Social Security will disregard any money that's in a special needs trust. Now there's different kinds. So there's what we call a pooled trust, and that's going to be what we consider first party money. Okay, so typically the first question we're asking when a vulnerable adult or adult disabled person receives money via an inheritance, is it first party money or third party money? First party money is money that the person has already received. So grandpa benefits grandson who has adult disabled needs $100,000. Okay, that's first party money because the grandson already has the money. As opposed to a third party situation where grandpa comes to somebody like me and says, I want to benefit my grandson who has special needs and I want to give him $100,000. How do I structure that? And so then we can preemptively, or proactively maybe is a better word, put it in a special needs trust so that it's spent by different rules, and then Medicaid doesn't receive any money out of that trust. And so what happens is we put those funds in a special needs trust, and then the trustee, which is the person that grandpa in our example would choose to administer the money, and the trustee would spend it on supplemental needs. So it can't pay for things that the adult disabled person is already receiving through their benefits, but it can pay for supplemental things. For example, travel, or fun. Well, here's a good example. I had a case once where we had a child who was in a pretty severe car accident, and he was disabled for the rest of his life. And so Social Security Disability, he was bedridden. So Social Security Disability would pay for bed A, you know, whatever kind of bed that was. But bed B was like the Cadillac of all beds, right? Like this was like the coolest bed and it had more things for it. So the special needs trust could pay for the difference in the cost between bed A and bed B so that the child could have the, you know, the Maserati bed, right? So, you know, the idea of the special needs trust is that you want to supplement the life of the adult disabled person. But if you don't do that planning, and they get the money outright, then we're looking at first party options, or they get kicked off their benefits. And under first party trusts, if the adult disabled person or child doesn't use all of the money, then Medicaid gets paid back. Under a third party trust, Medicaid doesn't receive any money from that trust. So there are some planning options out there. If you know, kind of do some of that proactive planning, that you can really enhance and benefit a person's life, you know, without affecting their benefits.
I think to add on to Tasha, one thing that I appreciate having Tasha in my life for this reason, but a lot of these, when they turn 19, that's when an adult child can receive these benefits as an individual, not as a. And so this may be the first time that a parent or someone is applying for benefits on behalf of this person. So Social Security, you were an adult at 18, and for Medicaid purposes, you were an adult at 19 and in Nebraska. And you may have not qualified for these benefits prior to that time, but once they do turn 19, that may be something that they do qualify for, but they may have had, you know, money from grandpa or something that was there that they may not qualify for that benefit because of that, but not because of income. It's based upon income and assets. So it's important when to trigger that 19 years old is that if they are going to plan on applying for benefits, it's important to again, someone get in touch with someone like Tasha to be able to help plan for that, and that won't be counted as a resource.
Thank you to you both for that answer. We're getting towards the end of our hour together, and there are no more questions in the Q&A. So if you have one and you want to ask it, now is the time. But I want to ask Sarah and Dina a question, and anybody who has an answer to this, because it's something that we're dealing with in a case right now, Elena and I, and that is when someone is an adult who might need a guardian, but they also have children. How does the guardianship affect their custody rights of their children? It's challenging to navigate that, but I'm hoping that this panel has some insight on that. And the narrow question, I guess, is if you are someone who is under a guardianship, can you maintain custody of your children?
So I guess my first question is, where I'm assuming you're asking about minor children.
Correct.
Okay. I think I mean, it's fairly fact specific, because I think that there can be, like you touched on earlier, Molly, a lot of reasons for a guardianship, right? And some of those are because there's an incapacity that exists all the time. And I think if that is the case, right, so maybe it's a developmental issue or an incapacity beyond just mental health. And I think in that circumstance, and again, when we talk about custody, we have to think about custody in a couple of different contexts. Legal custody, which is decision-making, and physical custody, which is where the children are. And so legal custody, I think if somebody is under a guardianship, whether it be for mental health or incapacity, I think legal custody is probably going to be an issue in the context of custody orders as it relates to dissolution or a custody matter. That doesn't mean that they are excluded. It doesn't mean that they don't get to have input or insight. But it may mean that if there is an impasse and a decision can't be made, that the other parent would then get to make the final decision or be obligated to make that final decision. Again, that's always in the best interest of the child. Physical custody, if the parent can be a safe and protective parent and has safe and stable housing, I don't know why they couldn't have physical custody and or parenting time. So, you know, there's the analysis for custody of minor kids is multifaceted. There's a lot of different components that you look at, but just because somebody has a guardianship, I would never say that it's an outward no, so to speak, or an obvious no, that they can't have custody or parenting time of any kind, or potentially even some ability to make some, or at least participate in legal decision making for a child.
That's very helpful. Thank you for that. All right. Well,
I think along that line too, what I have counseled clients, because we've had some cases, so at Hightower Ref Law, we do a fair amount of family law, not me in particular, but a lot of the other attorneys. And I think one of the things that I've counseled with the divorce attorneys on is just understanding and being prepared to meet the claims that will likely be made on the other side of the table, right? So if we represent the parent who may be under guardianship for whatever reason, just understanding that the other side of the table is probably going to be bringing evidence of that to the dissolution court if there's an argument about custody. And so how do we meet those claims, you know, whether it's an opinion from the treating doctors of the person who's under guardianship or, you know, other type of evidence, right? But I think just being really cognizant of what the claims will be and how can we meet those claims so that we can show the judge that, you know, despite whatever is going on in the guardianship case, that we still should have, you know, parenting opportunities.
And I will just say briefly that custody is always changing. It's something that can be relitigated if there is a significant change in circumstance. So if this is something that's temporary, that's not going to be forever, a parent can always come back and say, you know, the issue that put me under guardianship is done. It's no longer an issue, and I would like to have custody of my kids. I'd like to make those legal decisions. So as long as the children are still minors, you can come back and relitigate. There just has to be a significant change in circumstance. So I wouldn't be, you know, afraid if this is just a temporary thing of completely losing custody of your kids. It's a very loose kind of boundary on some of these custody orders.
okay. Well, that's very good and very helpful. We have reached the end of our hour together. And so I just want to thank our panelists once again as people are signing off and probably going to watch the Nebraska game. Thank you again for being here. It's been, no, there's some head shakes, no. Thank you again for being here and providing this information to the attendees. It is so helpful. We know that it's not always necessary to make an appointment and take time off of work and pay for just simple questions that can be answered in arenas just like this. And that's why we do these panels. So we hope to see everybody back. You guys are definitely going to be invited back. Thank you for spending some time Saturday morning with us. Check our learning center on blazeklawgroup.com for next month's webinar. It's going to be on scary guardianship stories. It's a special Halloween themed workshop. So we will see everybody next month. Until then, take care. And we support you. We're here for you and you're doing a good job. Bye, everybody.